Hello, I'm Vincent J. Russo of the Russo Law Group and co-host and creator of Family Comes First on CFN. I am thrilled to present my two-part series on wills, trusts, and avoiding probate. In this first part, we will tackle the importance of having a last will and testament and the benefits of a revocable living trust. First, everyone should have an estate plan. The most common structure is to have a last will and testament along with a durable power of attorney and healthcare directives. A last will and testament is a legal document that sets forth how you want to leave your assets and to whom and who will administer your estate, the executor. In addition, if you have minor children, you can provide for guardians to take care of them. Without a will, you are left to the courts and the laws of the state you reside in to determine who gets your assets and who manages your estate. Not a good plan. It leaves it open for family members to fight over your estate. For example, if parents with children die without a last will and testament, the court will decide on who the guardian will be for your minor children. If you die intestate without a will, your estate is settled by the courts, which means the judge, who does not know you, will be making decisions about your estate. Having a will allows you to control what happens to your assets after your demise. In order for a will to be valid, it must meet the requirements of state law, and it needs to be filed in the probate court for approval and the appointment of an executor. In New York State, we refer to that court as the surrogate's court. The probate court will then supervise the executor to ensure that your wishes are carried out under your will. Another alternative is to have a revocable living trust, sometimes called an RLT or living trust. In this structure, your living trust allows you to control your assets while you are alive, and then the trust acts like a will when you pass away. A revocable living trust is an agreement between you, the settlor, and the trustee. Typically, when you set up a living trust, you are both the settlor and the trustee. The trust agreement controls what you can do with the assets that you place into the trust. Since the trust is revocable and you are the trustee, you have total control. You have the right to revoke or amend the trust at any time, and you have access to the trust assets and income during your lifetime. In addition, you are in charge of managing the trust assets. One of the questions I often get from my clients is, how do I fund the trust? In order for the assets to be in the trust, you have to transfer title of your assets to the trust. The typical assets that are placed in a living trust are bank accounts by changing the bank account title to the name of the trust. Brokerage accounts, life insurance, real property, which can be accomplished by a deed transfer, and personal property. Another way to fund the living trust is to name the trust as the beneficiary of your asset. For example, naming the trust as the beneficiary of your life insurance policy, or annuities, or a brokerage account. Now, when it comes to taxes, during your lifetime, you report the income on your personal income tax return. The trust uses your Social Security number as the trust tax ID number, and there is no trust tax return to be filed. There is also no gift tax return required, and it's part of your estate for estate tax purposes, allowing your beneficiaries to get a step up in basis. Who should be the successor trustee is another important question and decision that needs to be made. There are three choices: a family member or friend, a professional advisor, such as your attorney or accountant, or a corporate trustee, such as a trust company or bank. The trustee has a job which is outlined in the trust agreement. The trustee's duties usually are collecting the income, paying the trust expenses, distributing income and assets to beneficiaries, managing the trust assets, filing tax returns when required, and providing accountings to the beneficiaries. In addition to the living trust, one should have a pour-over will just in case. A pour-over will provides that any assets that pass outside of your trust shall be transferred to the trust upon your demise. This is a safety net, just in case you own any assets in your individual name instead of the trust name, or you have not provided for a beneficiary designation. I look forward to the second part of my series, when I will focus in on avoiding probate. Be well and be safe. This is Vincent J. Russo for CFN in the Legal Know.